A federal judge has declared the machine gun ban unconstitutional. Let's talk about it. Hello Wolverines, John Crump here, and do we have a spicy one for you today? But before we get into that, there are many ways you can help the channel. I have a Patreon, channel memberships, and a local. All of those are listed below in the description. You can also head over to FatTac and pick up some John Crump merch. The cheapest way you can help is by liking, commenting, and subscribing. Now let's talk about United States versus Brown. Section 922.0 of the Federal Code makes it illegal to own a machine gun made after 1986 unless you are an SOT. This provision is thanks to the Hughes Amendment, which was meant to be a poison pill to the Gun Owners Protection Act. But the Gun Owners Protection Act passed with the poison pill intact. So now it is a law. So we know the law now, so let's talk about the case. First, I want to state, this case does not mean you can take your post-1986 machine gun to the range and start blasting off rounds. This decision only applies to the defendant in the case, and you can tell the judge didn't even want to do that. But Judge Colton Reese didn't have a choice. He is bound by the Supreme Court. Javon Brown was busted for having an unregistered machine gun produced after 1986. He was arrested and was facing 10 years in prison. He asked the court to dismiss the indictment because the law banning machine guns violates the Second Amendment. In the past, the courts used intermediate scrutiny to uphold the machine gun ban, but not anymore. This seemed to really get under the judge's skin. He wrote, Mr. Brown's argument was once foreclosed by decades of precedents, not anymore. In 2022, the Supreme Court established a new historical paradigm for analyzing Second Amendment claims. What the judge is talking about is the Supreme Court's Bruin decision that states that only things that the courts can use to determine if a gun law is unconstitutional is the original text of the Second Amendment, tradition, and history. First, let's read the Second Amendment. A well-regulated militia being necessary for the security of the free state, the right of the people to keep and bear arms shall not be infringed. Everyone should memorize that. The first question is Mr. Brown part of the people? He is over 18, which is the age of majority in the United States. That means that he is part of the political class. So that is one check mark. Now let's talk about the machine gun. Is that a protected arm? I think so, and the judge did too. Since Mr. Brown is part of the people and the machine gun is a protected arm, his conduct is presumably constitutional. Now the burden of proof shifts to the state to prove the law is consistent with the tradition and history of firearms regulations in the nation. They do this by presenting historical analogs from the founding era. Most consider the ratification date of the Second Amendment to be the founding era, although some on the anti-gun side will argue the founding era is 1868, the ratification date of the 14th Amendment, mostly because there was a lot more gun laws at that time due to freed slaves. That is for another video, though. Back to this case. In Rahimi, SCOTUS said that a historical analog does not have to be an historical twin, but it must be relatively similar. The examples the state used were too far different from Section 922.0 or too far removed. The judge rejected these. The state also tried to argue that machine guns are dangerous and unusual. In Heller, SCOTUS said that dangerous and unusual weapons could be banned. Remember, it has to be both dangerous and unusual. The courts determined that machine guns are dangerous, but since there are over 744,000 in private hands, it said that they are not unusual. Remember, in the stun gun case, the court said that 500,000 was enough for common use. The state then tried to argue that common use means common use in 1791. This would be grasping at straws, because that would mean that only muskets and flintlocks would be protected under the Second Amendment. The judge saw through this claim and in the end agreed to dismiss the case. Now he really didn't want to do that, but he felt that his hands were tied. Remember, this only applies to Mr. Brown, so maybe don't go showing off your unregistered machine gun just yet, just like the guy in my previous video. Okay, we'll be back at 5 p.m. Eastern with a live conversation with Mark Victor from AOR talking about his stances on the Second Amendment. It should be a fun conversation. I also have another video queued up. It's just waiting for something else to drop. You'll have to wait and see what that is, but once it does drop, it should be pretty exciting for everyone, especially if you live in an anti-gun state. With that out of the way, we are out of here. Stay ever vigilant, stay ever free, keep in the fight. Wolverines, MFers.